Just for that one's a good one.
Yeah, that's not good.
Oh.
That's a wall view. Sure.
We had so much fun.
Yeah, Walmart guy.
Helicopter.
Yeah.
Oh, say, so you don't think it's right for six.
I've been lost like
Yeah, I'm gonna be.
Yes.
I'll read it tonight, and then tomorrow we can work on it.
Yeah.
Okay.
I did.
Right, but I mean, you didn't find.
Sorry. I'm good. That's all that matters.
Alrighty. Excellent.
Is there anything else about your seeing other people and him seeing other people? Oh, well, good. People already dancing. Yeah.
Yes.
Was that fun?
He said. And then I get on and it's You didn't know it? You had no expectation to eat it?
So you eat fish?
I like mussels. You eat those. I eat sushi.
I'm like,
Sushi is so good.
talk about KFC.
There's a place in my house.
We have a school center. You know, oh, I didn't know. I have a friend who
Because I'm like the only person I knew.
Where?
Yeah, I see any other person till Monday. I was literally like, I think tomorrow in class on Friday, and there's a girl that said, like, you need to get back, I'm gonna go out and see you.
And she's also active.
You did what? I literally was just like, okay, cool, we have to argue against it, or is against this, this would be easy, and then you get there. Says. That's what I was gonna make argument that it's too subjective. It's unfair. Because in some of those cases,
And
they're
there's a nice dinner,
like,
nice lunch.
and they're still like,
Really?
fine options. So it's almost like, I'm just like, I
Um,
can do yours. Hey, we'll keep this, and whichever sticks. Okay.
No, you're not the only one. We're on the same boat.
That's my.
Thanks.
My brother,
Dude, I might have to get that app. Actually, when's it?
we close at 8. Yeah, I'm gonna run. Pop it over there. They stopped selling that at a certain time.
They still have them more.
Maybe I ate a little bit too before I came.
I'm still gonna buy it.
Mark doesn't care.
Oh, my brother. Like, strict vegetarian. And he did it for about a year and a half. And then he went to a conference, he was an Air Force, and he went to a conference in the Air Force. And the only non-vegetarian foods that they had that he could eat was fried cheese,
Not too bad.
All right, how you doing?
like French fries, and something else that was super unhealthy. And I was like, why would I
Oh,
eat
okay.
those? Chicken.
Have you heard of people like?
Yeah, it's hard to be
sister, like,
I mean, hard to be
vegan,
Yeah.
like, eating a shit ton of vegetables, eating just, you know, whatever plant-based. And like, she-
What?
Yeah,
That's impossible.
Well,
No.
That's what she said, she was like.
Pay more credit for that, or?
That's impossible.
If I stay inside of a certain amount of hours, I can do without having.
I think it just.
I think, I think,
For a female, it depends on your.
Okay.
body.
I was gonna say, I read some stuff where, I mean, and she was like, she was thinking like, wait,
Ben,
what?
if you get work.
I mean, some people can, I think it's maybe they're eating like the wrong types, or maybe just eating like. shit.
All right, found you love. Well,
Well, I'm sure she was eating like corn and potatoes.
I mean, that's,
Probably eating, like,
I feel like,
corn
I was about to say, she thought, yeah,
She
probably.
probably wasn't eating greens.
That's what I'm saying, like, I don't know.
Very much,
Just remember, think money.
No, I was thinking that.
Just
has flashbacks.
This guy called it Green Moolah, but you know. Yeah, Scott, we see someone in cash, you know, so we can cash Green Moolah.
Oh, yeah.
Yeah.
Oh my god. That's
You gotta come to
sweet.
Georgia, brother.
I,
I'm thinking about practicing up in Jackson.
He's got about 50 more miles to go.
One was more.
Yeah, actually, it's like 110.
No, are you talking about from here to Jackson?
No, from where I'm at. But no, it's probably about 100.
Yeah. So I figured it was like not a big market.
Already, and,
It's not.
apparently she wasn't on campus today, and then just didn't
Yeah,
tell me.
that's pretty well.
There's a lot.
Yeah.
So I literally just spent the last hour.
No,
typing
she,
up
you know how the last week she felt and whatever.
because
Did that did happen?
Apparently, they made it. I don't know.
it's not
Oh,
continuing.
So they should have had a doctor.
Like this whole
Like,
thing.
she'll die.
That's what I was-
Really?
I mean, they said,
They've always
yeah,
done.
it's any day now.
First aid.
Right, so they're gonna- so if it don't come out till it comes out.
I was hard to, like, present that.
sometimes it can go into
It's
just.
choose.
Well, then it starts happening. Sometimes. That's what
They
happens.
kept going back, kept going back.
We're gonna help.
I'll be here out there, I'll play that damn thing.
Are you gonna get your?
I mean, I'd be like, should we hold it? That looks nice, that's a nice place.
don't want to hold it.
I'm not newborn.
It stressed me out to be honest. I probably won't. I just like, I mean, I will when it's like 2 months old. But like, when it first goes out.
I'm not gonna drop that next.
Well, and also you have to hold its head. And I ain't got time for that.
Feels like a dog, you know, like dogs just pick up and crazy, but.
She's like, he made my and it's like,
I don't want to do anything to you either. I'll be like, but I'm not. I gotta shit.
About what?
Yeah.
Let's get over here.
he's involved in it, and that's what I'm like, say he took things and because and that's what the husband did. She's like, I had to come to me like never met before as she was that's the thing, I'm having people come up to me and ask me. He's just trying to get me on his side. I've done nothing wrong.
Yeah.
I mean, I'm not feeling I'm the most good person on campus. No, like, I think you're doing fine. Yeah, I know. I was like in that thing, they thought about it. They basically that Josh Leonard the kid that I got that. And I tried to be respectful and like them silly and include them. And it's like, I love it, I love it, I love that. And I'm like,
Yeah, fair enough. I know that, Emily.
Welcome back, everybody. Often I use the lapel microphone. I'm gonna give this one a try. Is it working? Does my voice travel through this thing? Yeah? You hear me in the back over the speakers or just over my mouth? I wonder. Should I hold it closer? I don't know. I'd like to be able to lay it down. Does the microphone still capture my voice if I lay it down? Yeah, but you're hearing me not through the mic. You're just hearing me.
Yeah.
Yeah. Anyway, does that help? Not really. Okay. All right. I'm just going to pretend the microphone is carrying my voice. But hopefully everyone in the far reaches of the room can hear me just fine. Thank you. Thank you for the thumbs up. Appreciate that. Well, welcome back, everybody. Maybe you had a chance to attend one of the university-sponsored masses or watch it on live stream. I was there at the Red Mass. I thought that turned out wonderful. So I was very happy to be there. I saw one professor from the university there. Maybe there's more than one? Yeah, I just saw one. But I was glad to see a professor from our university there. So that was nice. And then live streamed was the inauguration mass for the university's new president. So that was nice. So hopefully you had a chance to check out a Catholic mass. You know where I stand on those. I love them. So I thought the Red Mass, for all the folks who volunteered like yourself, thank you. Thank you for volunteering. It was a pleasure to introduce you to Bernadette. Is she a hoot or what?
She did.
She's great.
Now I know what you're talking about.
Right? Yeah, I can't stop. So with that said, you always indulge me, always kind enough to let me start with a prayer. Of course, it's not a moment of silence. I not only believe in my Lord and Savior Jesus Christ, I believe in the First Amendment. So if you don't care to be silent at this moment, then don't. On the flip side, if you care to join me in the prayer, I'd be flattered to be praying with you. But regardless of whether or not I'm praying with you, I'm praying about you and I'm praying for you. This prayer goes out to you. I've received a few emails over the past few days reminding me that finals are near. Finals are coming. So this prayer goes out to you in your preparations. Hopefully, the good Lord will let you carve out the time. And I know taking a class at night like you do here, that probably means you're working all day. Is that true for many, for most, for all? Well, whether or not you are, I'm sure there's other demands upon your time other than studying. So my prayer for you is that you're able to find the time, adequate time, quality time, and quantity time to study the things you need to study so that you can synthesize this information, that you can apply it, and that you can succeed not only on the exams that you'll be taking, but in this beautiful career, the practice of law that you're about to embark on. And that was the homily from the Red Mass. It was about lawyers, and it was about judges, and it was about the good we do for society. I felt warm in my heart when I heard that homily, because where I stand when it comes to the law, I see it as a profession of service, and I know many, if not most, if not all of you do too. So my prayer goes out to you. My prayer is that you'll succeed in entering this profession of service, and that you'll put the serve in legal service when you join the club and you serve your clients. So this prayer is for you in the name of the Father, and of the Son, and of the Holy Spirit. Amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. Remember, O most gracious Virgin Mary, that never was it known that anyone who fled to your protection, implored your help, or sought your intercession was left unaided. Inspired by that confidence, I fly unto thee, O Virgin of Virgins, my mother. To thee do I come, before thee I stand, sinful and sorrowful. O Mother of the Word incarnate, despise not my petition, but in your mercy hear and answer me. Amen. Father, Son, Holy Spirit. Amen. All right, so today we move on to chapter 6. Today we talk about amending Florida's Constitution. And in so doing, I want to take a comparative approach. I want to give you some transferable skills if you happen to choose a state other than Florida to practice in. I want to talk about generally how state constitutions are amended, and then specifically how Florida amends its constitution. But there's a question. Yes, I was up here stuffing them into envelopes, and hopefully the 10-minute break will be enough for me to finish stuffing them in envelopes, and then I'll be able to hand them out. So yes, sorry for the stuffing delay, so to speak, but I am the official envelope stuffer. So, and speaking of housekeeping, they require me to take attendance. So I'll pass that.
I have no sense. No, but I do have to leave at the break.
So our topic then is amending state constitutions, and specifically amending Florida's constitution. How are state constitutions amended? And what we find is that this is not a matter of federal law. It's not a matter of federal rules. It's not a matter of federal regulation. Indeed, the answer to how to amend each state's constitution is found right there within the constitution of that state. So if you want to know how to amend that state's constitution, look at the text of that state's constitution. Florida is no exception. Here you're going to want to look at Article 11. And if you'd like my discussion of it, you'd like to look at Chapter 6 of the text. Now, one way that we amend constitutions typically in America is that state legislatures have a role in how the Constitution is amended, and indeed in making proposals for amendments to the Constitution of that state. Florida is no exception. Here, the Florida legislature, with 3/5 of approval from the voting body, so that's a supermajority, they can enact what becomes a proposal. Once they vote and they get that 3/5 vote of passage in both the House and the Senate, of the Florida House and the Florida Senate, what we have is a proposal for an amendment to Florida's Constitution. We have not yet amended Florida's Constitution, but we do have a proposal. Another way that state constitutions can be amended are various commissions. Here in Florida, we have 2 commissions. We've got a Constitutional Revision Commission, which meets once every 10 years. We've also got our Taxation and Budget Reform Commission. Now, when it comes to our Constitutional Revision Commission, that is unique to the state of Florida. I don't think you'll find that particular commission in the Constitution of any other state. But its purpose is spelled out in Article 11, and its membership, to a certain extent, is also spelled out in Article 11 of Florida's Constitution. And those members gather, the first thing they do as a commission is to enact the rules of that commission, the rules of procedure that they will follow. Following those rules of procedure, they may create one or more proposals for an amendment to Florida's Constitution. And if pursuant to the rules they have an adequate vote, then again, they haven't amended Florida's Constitution, but they have created a proposal, a proposed amendment to Florida's Constitution. Another way state constitutions are amended is voter initiative. This is perhaps the most famous way, or depending on your perspective, may be the most infamous way that state constitutions are amended. So this is an example, probably our closest example to true democracy that we have here in our democratic republic of the United States of America, insofar as the voters are asked to vote yes or no directly, not through their representatives, but directly upon the topic of the particular constitutional proposal. So you get to vote directly rather than through your representative. So this may be why state constitutions typically are substantially longer than our federal constitution. This may be why that amendments are more frequent for state constitutions than they are for the federal constitution. This may be why that sometimes state constitutions can be quite mundane. They may have topics in there that you might not consider lofty or idealistic. For example, our state constitution here in Florida contains constitutional rights for pregnant pigs. So if you happen to own a pig in the state of Florida and your pig is pregnant, it has stated textual constitutional rights right there in Florida's constitution when it comes to how it's treated, how it's caged, the size of the cage, things of that nature. Now, last time I checked, our federal constitution didn't address the topic of pregnant pigs, but our state constitution does. Also, our state constitution sometimes might contradict itself. An amendment might amend an amendment. For example, in the history of Florida's constitution, there was once an amendment requiring the legislature had to build a bullet train, a high-speed rail system, starting here in Orlando and heading down to South Florida to the Miami area. A few years later, there was an amendment that said the legislature was forbidden from building a high-speed rail that ran from here in Orlando to South Florida. So these amendments can sometimes be contradictory, and these amendments sometimes can be controversial. If you voted in Florida, I would hazard a bet that you've seen on your ballot, whatever election it might have been, you've seen on your ballot a proposal that you had to vote for. And many of those proposals come from voter initiative. If you spent any time in a public place in the state of Florida, I bet you've seen an individual walk up to you and ask you if you're a registered voter and if you'd like to sign their proposal. So this is true democracy in action, is it not? It's direct democracy, far more direct than having our elected senators or representatives propose bills and then enact them in that way. But despite the origin coming from the people, these voter initiatives, once there's adequate, and here in Florida, when it comes to a voter initiative, there has to be a single subject. The single subject rule does not apply here in Florida when it comes to a commission proposal. But when it comes to voter initiative, it must address just a single subject, and 8% of the registered voters have to sign off on it. If so, we have not amended the Constitution, but we have created a proposal to amend. And another origin of a potential amendment, if you want to call it that, would be to take our state constitution and tear it up and start anew. Stated somewhat differently, you might call a constitutional convention. If you call a constitutional convention, then you can replace the existing constitution whole cloth. You can pass a new one. When's the last time that happened here in the state of Florida? 1968. 1968 was the effective date of the current constitution of the state of Florida because of its origin from a constitutional convention. If that happens again, does that mean once the convention's over, we've got a new constitution? No. Again, we have a proposal. So what becomes of all these proposals. You see, regardless of the origin, the result wasn't an amendment, the result was a proposal. What happens with all these proposals, regardless of the origin? They all go before the voters. They all go before the voters of the state of Florida. And regardless of the origin, it's the voters that decide whether or not this becomes an amendment to Florida's Constitution. Before it goes on the ballot, there has to be drafted a ballot summary. Therein lies the opportunity for lawyers or educated citizens to try to get our court system to intervene. And indeed, if you look at the chapter in our book, you see case law examples where there have been challenges to either the amendment itself or to the ballot summary. But assuming that litigation ends with allowing the voters to vote, then it is the voters that decide, yes or no, whether or not that becomes an amendment to Florida's Constitution. Before that election, we're going to publish the ballot summary in a newspaper twice in each county of the state of Florida. If 60% of the voters at the polls ultimately vote yes and approve of that amendment, then it becomes effective on the date stated within the amendment. But what if there's no date stated within the amendment? Well, then, of course, it becomes effective on the first Tuesday after the first Monday in the first January after the election. Of course, you knew that. I'm sorry I wasted my breath telling you that. So there you go. That's how Florida's Constitution can be amended. That brings us now to Chapter 7. Chapter 7, I'm sorry, did I belabor Chapter 6 too much? All right, that brings us to Chapter 7. In Chapter 7 now, we're going to talk about Florida's constitutional right to due process. And in so doing, we're going to be talking about a Florida constitutional right of access to courts. Access to courts. Now, that constitutional right may be a misnomer. We'll take a closer look at that and see if that was a good thing to call that particular constitutional right. But we're talking about constitutional right to due process. Now, Florida's interpretation of the Florida constitutional right to due process involves conclusive or irrebuttable presumptions in Florida civil law cases. And of course, the right to due process is not unique to state constitutional law. You studied federal constitutional law, you're familiar with the federal constitutional right to due process. Why then have yet another iteration of such a right within the state constitution if it's already in the federal? And the answer there to that question is the same answer that we've seen time and time again when we've studied rights that are similar. First, prior to 1868's 14th Amendment to the federal constitution, the primary source of rights were the rights we found in state constitutions when it came to protection from state government. Also, as we've discussed time and again, and as you wrote those beautiful essays regarding Michigan versus Long, a state constitution can, if it does so properly, can provide greater rights than our federal constitution. We know that a state constitution itself can be unconstitutional because the federal constitution requires minimum rights. But it's not just the federal constitution that is the source of our rights. It's also federal law. It's federal statutes. It's federal case law precedent. It's the Code of Federal Regulations. It's the actions or inaction of federal agencies. All those sources of federal rights must be upheld. We can think of them as a floor below which no state constitutional right may sink. The full panoply of federal constitutional rights, regardless of their federal origin, must be upheld and can't be contradicted by a state constitution. But if the state constitution has an adequate and independent state basis, then that state constitution can experiment, can be that laboratory of democracy, can experiment on granting greater, perhaps even new rights to the state's citizens. But we can't fail the test of adequacy, by which we mean we can't sink below the floor, by which we mean we can't deny the state's citizens anything less than the full panoply of federal rights. Also, there must be an independent basis. So it must have its origin in state law. And you know that, that's just a recap. So with that in mind, what's that have to do with the state right to due process? And I would argue that in a very narrow sense, in a very specific instance, Florida's Constitution and its right to due process does indeed create new rights that are absent from the federal Constitution. And I may be splitting hairs. I may be talking about a very specific instance where this applies, but it's important to note that it does apply. Substantive due process and procedural due process, as provided by the Florida Constitution, are the same rights as provided by the U.S. Constitution. But with that truth having been acknowledged, perhaps the argument could be made, and I will attempt to make it. Perhaps the argument could be made that the right of due process of law under Florida's Constitution slightly exceeds that granted by the U.S. Constitution, at least insofar as Florida constitutional law jurisprudence makes much ado about rejecting as unconstitutional any civil law of the Florida legislature that establishes a factual presumption that may not be rebutted by contrary factual evidence. And I'm quoting from that particular page of your text. Now, when it comes to federal constitutional rights, and when it comes to the criminal law under federal constitutional rights, there is a federal constitutional right enforceable throughout our nation, a criminal law right for the criminal accused to be free from a conclusive, or what Florida's case law refers to as an irrebuttable. Is that even a word, irrebuttable? It is. I prefer conclusive presumption, but the case law often says irrebuttable presumption. But I am speaking of the same thing. I am talking about a presumption that cannot be overcome even by contrary facts. So in the criminal law, that's unconstitutional under the federal Constitution. But at least so far, it is not unconstitutional in the civil law when it comes to the federal Constitution. That, the civil law, is where Florida's constitutional right to due process is a greater right than the federal constitutional right to due process. Because under Florida's Constitution, we have a Florida constitutional right to be free from a conclusive or irrebuttable presumption, both under the criminal and the civil law. So you see my specific instance that I'm pointing out. I may be splitting hairs, but I am making the argument that there is a greater protection for Floridians under Florida's Constitution when it comes to procedural due process, because in a civil case, our state constitution protects us Floridians from a conclusive presumption or irrebuttable presumption. Now, what's the test? How do we know whether a conclusive presumption or an irrebuttable presumption is unconstitutional under Florida's Constitution? And the test for constitutionality under Florida's Constitution is twofold. First, there must be a rational connection. That's the term from the case law, rational connection. There must be a rational connection between the fact proved and the ultimate fact presumed. So the statute can say, if you prove this, then we presume that. But in order for such a presumption to not run afoul of Florida's Constitution, there has to be a rational connection between the two. And you see the word rational. Remind you of any standard of review under federal constitutional law? Yes, remind you of the rational basis test. And at least in my opinion, as I look at the case law that applies the rational connection test, it seems to me to be equivalent to a rational basis review. That's my hypothesis. But this is a twofold test. That was the first. The second is that there must be a right to rebut the conclusion in a fair manner. So despite the fact that you proved the predicate fact, the requisite fact, and in so doing became entitled to a presumption, still there must be a right for the person burdened by that presumption to rebut the presumption in a fair manner. So that is the test for constitutionality of a presumption. But we have to remember there's a difference between a presumption and an inference. Do we understand the difference between a presumption and an inference? Would an example help?
Yes.
You and I are having a fight, a loud, vicious argument on your front porch. One of us pulls a gun. We both head inside the house. Suddenly we're out of view of everyone, but still within earshot, and we hear the gun fire. One of us, unfortunately not me, then exits the house holding that same gun, but it looks a little bit different now because there's smoke coming out of the barrel. Everyone who heard the gunshot and saw the smoking gun rushed into the house to find me on the floor with a bullet in my chest. Which eyewitness can testify that they saw me get shot? Under those facts, no one, right? But with all those facts in evidence, the jury can reach an inference, can they not? That you shot me when we went inside the house. That's an inference. You've proven certain facts, which then allow the fact finder to infer the existence of another fact. We were arguing, somebody pulled a gun, we went inside, we heard the gun fire, you came outside, you're holding a smoking gun, I didn't come outside, everybody witness-wise went inside, saw me laying on the ground shot. There's no direct testimony, there's no eyewitness account of me getting shot, but the jury can certainly make that inference, can you not? That's different than a presumption. A presumption would read something like this. If you represent an injured worker in a Florida workers' compensation case and prevail in obtaining money benefits, you're entitled to a reasonable fee, and it's presumed that an additional 10% of what you succeeded in obtaining would be a reasonable amount to be awarded to you by the employer from whom you succeeded in that workers' compensation. Here we have a presumption. We still have requisite facts to prove, right? Got to prove all those things, that you represented an injured worker, that it was in a workers' compensation case, that you prevailed against a denied claim, that you obtained monetary benefit. You even have to quantify and prove the amount of those benefits. You then also have to prove how much 10% is. And then the legal presumption is that that amount is reasonable. Do you see the difference between an inference and a presumption? And it's important to see that because this constitutional right applies and protects us from presumptions, but it neither applies nor protects us from inferences. Okay? So it's important to know the difference. You read these two cases. Yes.
Can we go back one second?
Yeah. Inference versus presumption.
Yes, and this helped a lot. Is it fair to say that our inferences are typically applying to building some sort of case, putting facts together, connecting things, whereas
I love that. Yes.
Okay,
Yeah.
so it's kind of three sides.
So you build the case.
Right.
You may be missing, in my hypothetical, the actual eyewitness who saw someone pull a trigger and a bullet fly from a gun and enter my chest.
Right.
But gosh, you've proven
Connected the other
so
dots.
many things that allow that inference to easily be
Right.
made.
But the
So you've
dangerous-
built a case.
Right.
Yeah.
Okay, so then, and then the dangerous thing from the presumption is when you have a bunch of facts, but you close it, put it away, the presumption is the dangerous thing, and that's kind of more looking retroactively at it.
Well, the presumption arises from a law, rule, or statute,
Okay.
whereas the inference arises from the facts themselves. So as you build the case and you prove these facts, the jury in their mind reaches a necessary inference. That's not when we're putting this irrebuttable or conclusive presumption constitutional test. We're putting this constitutional test upon laws, rules, or regulations that create a presumption. So therein lies the difference. Yeah, thank you. Makes sense? Yes.
So in short, should it facts minus the analysis?
Okay, that's one way to put it, that a presumption yields facts minus an analysis insofar as you've proven certain facts, and therefore you're entitled by law to certain presumption. So to view the mechanics of that, you'd be entitled to to a jury instruction. Ladies and gentlemen of the jury, if you find that he's proven this and that, then you must also find this to be true. So, of course, there has to be a right to rebut it. So that's going to be part of the jury instruction also. But the presumption is going to arise from a law, rule, or regulation. It's not just the natural occurrence of building the case. It's more than just what the facts lead you to conclude. It's an additional conclusion that the law intervenes and applies to the case that you're building anyway. It's a legal presumption arising from a law, rule, or regulation. Make sense?
Yes.
Okay. So you read these two cases and they both applied Florida's constitutional right under the Florida Constitution to be free from the conclusive or the irrebuttable presumption. You saw Hall versus Ricci America. That was the first of these two workers' compensation cases. There, the injured worker, under those facts, would have been injured regardless of whether or not the worker was high or intoxicated or under the influence of drugs or alcohol. But the workers' compensation law gave the employer the right to a drug test after every injury. That employer had a drug-free workplace in place and proved it, so they were entitled to the drug test. The drug test was administered. It was administered properly. They dotted their I's, they crossed their T's. The physicians did the double test. All the statutory facts were proven to give rise to the statutory presumption. And the statutory presumption was this: if you flunked the post-injury drug test, then you received no benefits. So the trial judge, therein called a Division of Administrative Hearings Judge of Compensation Claims, or JCC, the JCC holding the bench trial noted, you've proven that you would have suffered these injuries regardless of whether you were intoxicated. But the law is what it is, says the fact finder, says the JCC. A legal presumption is here. So I'm denying any and all workers' compensation benefits to you. On appeal, our District Court of Appeal applied Florida's constitutional right to be free from an irrebuttable or a conclusive presumption and said that this law violates that state constitutional right because the injured worker had no fair manner to rebut the conclusion. Even the fact finder, the JCC, said that there would have been this injury. There would have been this right to workers' compensation benefits regardless of intoxication. But the worker wasn't allowed to rebut the presumption, even with that truth, even with those facts. So Hall versus Ricci America stands as an example of this constitutional right to be free from an irrebuttable or conclusive presumption and how it applies to strike down that statute, which appears in Florida's Workers' Compensation Law, Chapter 440. And again, the second case we looked at, Castellanos versus Next Door Company, yet again arises out of Florida's Workers' Compensation Law, Chapter 440. Here we were talking about the presumptively reasonable attorney fee to be awarded to the injured worker's attorney. The statute then, as it does now, said that there's a requirement for a reasonable fee. The statute then spelled out that if there are money benefits obtained, that 10% of those benefits is a reasonable fee. But the Supreme Court of the state of Florida also noted that proven before the JCC, the fact finder, was that there was a minimum and a reasonable amount of hours that the injured worker's attorney had to work in order to obtain that result. The experts and the attorney himself testified that that's the minimum number of hours that had to be done. And taking those minimum hours and divided by the reasonable fee, as the statutory presumption required, yielded $1.68 per hour. You're law students. How many of you would like to work for $1.68 an hour? Go ahead, raise your hand. I'm hiring anyone who's willing to work for $1.68 an hour. What happened? Adjust the decimal point. So you're willing to work for $168 an hour. You're still selling yourself short. Yes. But it's better than $1.68. I agree. I agree. Yes. But again, Florida's Supreme Court in this case, instead of the District Court of Appeals in Hall versus Reaching America, found a violation of the Florida constitutional right to be free from irrebuttable or conclusive presumption. Because the court held in a rather convoluted way, which is why I really had a long version of the case in there. Typically, I cut the cases down to size a lot more than I did with Castellanos, but there's a convoluted way they got to the point of saying that it's their job as a court to choose what is reasonable, and that it was unconstitutional for this part of Chapter 440 to create this presumption and leave an attorney with $1.34 as a reasonable hourly rate. So there were two examples of how that works. What questions do we have about Florida's right to procedural due process and how it's different than the federal right? You have no questions for me, so I'll have one for you. It's my hypothesis that Florida's Constitution and its procedural right to due process is different than in the federal. What do you think of my hypothesis? Am I right or am I wrong? Am I correct or am I incorrect? Is there any difference whatsoever? I argue that there is in that very narrow case of a civil presumption, because I don't see in the text of the federal Constitution or the cases interpreting it where there's a protection in a civil case, such as workers' compensation, which you saw in those two Florida cases, to be free of a conclusive or an irrebuttable presumption. I acknowledge that under a criminal case, if your freedom's on the line, the federal Constitution is going to protect you from an irrebuttable or conclusive presumption. But I don't see how the federal Constitution protects your money, your wallet, your civil rights, your non-criminal rights from an irrebuttable presumption. So give it some thought. Maybe I'm right, maybe I'm wrong. I'm here to educate, not to indoctrinate. You're free to disagree with me. I'm just making my argument. And that brings me to another instance where I would argue that Florida's Constitution provides a greater right than the federal system provides to Floridians. And that would be a right of access to courts, which I warned you may be a misnomer. You'll have to decide that. So our right of access to courts comes from Article 1, Section 21 of Florida's Constitution. Article 1, Section 21 says that the court shall be open to every person for redress of any injury. Hey, well, how's it going? No, it's going pretty good. Yeah, we're talking about Article Section 20.
Yeah, I read that.
Yeah. And it's a right of access to courts. But I've got the hypothesis on the table that there may be a misnomer. And first, I'm turning to the text of the Constitution. Because you know me, I turn to the texts of Constitution. Maybe I'm a little loco on that, huh? Yeah. They allow me to teach at a law school even though I read the texts of constitutions. Who'd have thought, right? Yeah, but the text here says, the court shall be open to every person for redress of any injury, and justice shall be administered without sale, denial, or delay. Where's my historians in the crowd? Where'd you see this language before? You saw it at Runnymede. You saw it in the Magna Carta. Magna Carta had this. Who studied Magna Carta? No Magna Carta scholars. This is language borrowed not from the federal constitution or any state constitution, but from Magna Carta. 39 states have one of these open courts or remedies clauses in their state constitutions. 39 states, Florida being one of them. But Florida's interpretation, or I would argue more accurately, its advancement, its application of its remedies clause is unique. It's more advanced, is more applied. Its jurisprudence is more fleshed out than the other 39 states. These remedy provisions have resulted in a myriad of interpretations by state courts. In the last few decades, for example, injured parties have used state remedy provisions to challenge tort reform, such as workers' compensation acts, or statutory caps on medical malpractice damages. And in my practice, this is where I first encountered the right of access to courts. It had to do with challenges to the constitutionality of Florida's workers' compensation law. You also see it often when it comes to malpractice or when it comes to tort reform, often on a state-by-state basis. Those who are attempting this type of reform turn to the state's open courts or remedies clause. State constitution's access to court clause is often at the epicenter of the historic power struggle between legislatures and courts. Does that make you interested in this? That's interesting, right? Yeah, very interesting. Yeah. Okay, but I find it interesting, and I'll try not to bore you with it. But I believe this is certainly worth studying because we're finally at this place that I've been talking about, this week 10, right? That I've been talking about for 10 weeks, where allegedly the hypothesis has been that every state can be a laboratory democracy, right? That without denying the full panoply of federal rights, we can grant our citizens a new or greater right. Here it is. Here's a new right. Here's a greater right. It's a right of access to courts. I know what you think you're saying, McGinley. We got the Americans with Disabilities Act. We don't need this. What I'm saying, however, is that in our state, like the vast majority of the 39 states, this particular state constitutional right has been interpreted to have both a procedural aspect and a substantive aspect. I wrote a law review article and they published it, and I called it that. I called it the procedural right of access to courts and the substantive right of access to courts. I'm hoping the terminology catches on because in many states, Florida being among the most advanced, there's more than just the physical access to courts. There's more than just rights for the handicapped to walk in the door. What there is a right to a remedy, a right to not have the state legislature abolish and take away a common law remedy or a statutory remedy. The right is never absolute, as most constitutional rights are not absolute. But when particular criteria can be met, then the state legislature, its hands are tied and it becomes powerless from taking away that remedy that exists. So it's a right to remedy. It's a substantive right. And Florida has interpreted that particular substantive right in its seminal case of Kluger versus White. If you're going to know a case by name in Florida constitutional law, and you can only know one, I hope you'll know more than one. But if it's like, hey, McGinley, all I got time to do is learn one case name in Florida constitutional law, I'd pick this one, Kluger versus White. And the reason for that is Kluger versus White interprets Article 1, Section 21. That's our access to courts clause, in such a way that it creates a rule of law that we apply to determine whether or not there's been a violation of Article 1, Section 21. Thanks to Kluger versus White, we don't take the text of Article 1, Section 21 and use it as the test, because Kluger versus White is the test for determining whether there's been a violation of Article 1, Section 21 and the access to courts. Now, you've read Kluger versus White. You can summarize it however you wish when it comes to the rule of law. But I've summarized Kluger versus White in this particular fashion, and I believe I've chosen my words wisely. I believe I've incorporated all the elements of the test into a single screen. Let's take a look at that screen. The first element of Kluger versus White asks whether the particular right to a remedy, stated somewhat differently, whether the particular cause of action, stated somewhat differently, whether the particular claim or lawsuit is a protected remedy, a protected cause of action, a protected claim or lawsuit. Because not every remedy or cause of action or lawsuit is protected. Which ones are protected? The ones that existed as of 1968. 1968. Why are we picking 1968? Do you remember two things? You'll know why. First were your canons of construction. You remember studying those, right? We interpret the language of the Constitution to mean what it meant to those who voted yes or no in adding that language to the Constitution. And as I mentioned earlier in this lecture, you may have caught it, we spent an exhaustive amount of time on how to amend Florida's Constitution. I mentioned how the last time the people of the state of Florida tore up their old Constitution, so to speak, or had a Constitution convention, to be more specific, and enacted a new Constitution was 1968. So which causes of action, which remedies, which lawsuits are protected under Article 1, Section 21, as interpreted by Kluger versus White and its progeny? Only those that existed as of 1968. Okay? So what if I create a new cause of action this year? Everyone has the right to a battery-operated car. It's a constitutional right. And then after creating this constitutional right, I realize I've just bankrupted the state of Florida. So I pass a new law saying no one has a right to a free battery-operated car. Can you then say, oh, you've violated my rights under Kluger versus White? No. Why? Because no one had a right to a battery-operated car before 1968. Were there battery-operated cars before 1968? Probably not. Maybe little toys, but not like the Teslas, right? Not like the Prius, right? Yeah, it's another battery-operated car. None of those. So my point is, the first part of Kluger versus White asks whether this is a protected cause of action, whether it's a protected remedy. If it is, then what is it protected from? What is it you can't do to it if it is protected? It is protected from being abolished. So if the cause of action is protected, meaning it existed before 1968, then abolishing it violates the substantive access to courts clause. Violates Article 1, Section 21 of Florida's Constitution as interpreted by Kluger versus White and its progeny. But I believe I've chosen my words wisely, because what you can't do is abolish it. What you can do is nearly anything short of abolishing it. What if I change it? Yes, you can do that. That's not a violation of Article 1, Section 21, as interpreted by Kluger versus White. What if I tweak it? What if I make the burden of proof harder? What if I change the procedure for bringing the cause of action? What if I change the burden of proof? What if I change the modicum of proof? What if I mess with it? All that you can do without violating Article 1, Section 21, as interpreted by Kluger versus White. The thing you can't do is to just abolish it. Because if you do abolish it, then you've got to satisfy one of these two exceptions. The first exception has a single element. The second exception is in two parts. Let's look at the two alternative exceptions. So if it was a protected cause of action and you did abolish it, then you violated Article 1, Section 21, unless you've provided a reasonable alternative. Or there's both an overpowering public necessity and no alternative method of meeting that public necessity. So do you see the test as I've written it? And you read Kluger versus White, you read the cases in this chapter. Maybe you would phrase the test differently, but I think you'll agree that I have phrased the test both concisely and accurately. If a cause of action existed prior to the 1968 Constitution, then abolishing it violates access to courts unless either there's a reasonable alternative provided, or if you didn't do that, then you both show an overpowering public necessity to abolish, and you show that no alternative method of meeting that public necessity, nothing short of abolishment, will do. So there it is. Broke it down in numbers for you. And no, that's not a typo. I used the number 3 twice just to emphasize it's either or. So there's the test. Makes sense, right? You could apply that, right? If you saw some factual scenarios, you could apply this test and get it right, couldn't you? Yeah, so let's do that, shall we? All right, let's do that. Let's look at hypothetical number 1. Hypothetical number 1. After successful lobbying financed by Uber, trying to get your guard up here, huh? After successful lobbying financed by Uber, the Florida legislature enacts a so-called guest statute. Euphemism. The guest statute protects car drivers from claims of negligence from their passengers and guests. Right? Driving your car, last thing you want is people whose safety depends upon you bringing a claim against you for violating their safety. So the guest statute protects car drivers from claims of negligence from their passengers and guests by requiring the passengers to prove a higher degree of negligence over and above ordinary negligence. You remember duty, breach, causation, injury? More, says the guest statute. Specifically, you've got to dismiss without recovery any lawsuit where the passenger just cannot prove abnormal and grossly negligent behavior by the driver. Ordinary negligence, dismissed. Have I violated the Florida constitutional right of access to courts? Have I violated Article 1, Section 21 as interpreted by Kluger versus White and its progeny? Some hands have gone up. What's yours first?
Yes, no, you do not, because it doesn't abolish, it stops short of by changing the level of evidence you must prove.
So one possible answer on the board is no, because they didn't abolish, I think you're arguing. What do you say?
I also say no.
You also say no, but why?
I consider it a reasonable alternative. It's pretty much the same thing, just adding an extra prong, maybe, you increase the level of what's required to prove, but, so you're altering the standard, but
Okay.
you're not changing it. And like he said, you're not abolishing it, you're just modifying it.
So you agree that it's not abolished, but you add that it might even meet an exception. What say you?
I would say we have a fundamental right to protection from ordinary negligence. This strikes me as the scenario where the gym is trying to absolve themselves of any damage at all in these waivers, and it seems like too much protection. I think that you are losing a fundamental right by requiring gross negligence to be proven. So I would say yes, it violates access.
So you say it violates. So 2 no's, 1 yes. Hate to say it, the no's prevail. The yeses do not. My citation is McMillan versus Nelson, Florida Supreme Court, 1942. Why 1942? Because that was the era when guest statutes became popular. We saw them popping up all over the nation. Insurers were worried. They were writing insurance policies, And then who made a claim? The driver and the driver's wife and the driver's best friend and the driver's 2 kids. How do I know these people are in the car, thought the insurer. Everybody keeps making a claim every time there's a wreck. Let's go state to state and pass a guest statute. So that's what happened. But unfortunately, when it comes to Florida, Article 1, Section 21, access to courts as interpreted by Kluger versus White, McMillan versus Nelson, and other cases tell us it does not violate Florida's access to courts. But if it's any consolation prize for those that argued it did, Florida's Article 1, Section 21, and its interpretation found in Kluger versus White is unique among the 50 states. So I'm not telling you that you're necessarily wrong somewhere else. But when it comes to the Sunshine State, the land of the hanging Chad, the answer is no. And what the courts tell us is that the rationale you both agreed upon is the solid one. They found that this didn't abolish the cause of action. You see how you still had to prove negligence, but instead of proving ordinary negligence, you had to prove abnormal and grossly negligent. You increased the requirement of the negligence, you increased the modicum or burden of proof, but you didn't abolish the cause of action. So you didn't run afoul of access to courts as found in Article 1, Section 21 of Florida's Constitution and as interpreted by Kluger versus White and its progeny. So I don't need to satisfy either exception. But I respect, I dare say I love your argument, because personally I would never go to court without a backup plan. Certainly I would argue to the judge that we have not abolished the cause of action. And without conceding that I'm wrong, because I'm not, I would say that even if this abolished the cause of action, I've met the requirement of a reasonable alternative, which was your argument. I love that. Hypothetical number 2. In an effort to attract new employers to relocate to Florida, have I got your card up yet? Lobbyists. The Florida legislature made Florida employers immune from lawsuits. What? Immune from lawsuits by employees for injuries arising out of the course and scope of their employment. Oh, but there's an exception. Yeah. The employee has the burden to show that the employer deliberately wanted to cause that particular employee that type of bodily harm that he suffered. For example, if the employer deliberately wanted to kill that specific employee, that would be one of the exceptions. Yeah. Okay, so murder is not excluded. That's so generous. All other claimants are limited to a statutory scheme of benefits. But you know what? We're not going to pay them everything. We're going to leave out loss of consortium. We're going to leave out pain and suffering. We're going to leave out punitive damages. We're going to give them goose egg, 0 for all that. And what's left of the economic damages, we're just going to pay them a percentage of that. We'll pay their medical bills too. Hey, let's throw in a fee schedule for the doctors. Better yet, the injured person can't choose the doctors. We'll let the employer choose them. We'll give them a one-time free change of physician to another doctor, the employer's choice. Have I violated Article 1, Section 21? Access to courts as found in Florida's Constitution, interpreted by Kluger versus White and his progeny. Your answer, your suggested answer, what do you think?
No, because as much as this sucks, this is a reasonable alternative, and what it prevents is double dipping from people trying to get workers' comp benefits and torts. So
What did you call these benefits?
workers' comp?
Workers' comp benefits. Did I describe a real law here?
Yeah.
Yeah, I described Florida Statute Chapter 440, the Workers' Compensation Law.
Yeah.
Yeah.
So if you want workers'
Yeah.
comp benefits, then you forego tort, but if you want, or, one or the other.
Yeah. You agree?
Yes.
You agree? You're all right. Indeed, in Kluger versus White, when they wanted to cite to us an example of what a reasonable alternative might look like, they cited to Florida Statute Chapter 440 Workers' Compensation Law. So did we abolish a cause of action? Well, yes, look at the hypothetical, or just look at Florida Statute Chapter 440, because they're one and the same. Floridas are immune. It's called the exclusive remedy provision. They can't be sued. You can't bring them to court. If you do, there's a summary way to get the case dismissed. If the judge errs and doesn't dismiss, it's an appealable non-final order. You can march right off to the appellate court right then and there. So yeah, Kluger versus White says that that's a reasonable alternative. You might argue, that doesn't sound very reasonable to me. And when I spent 23 years defending United Airlines against workers' compensation claims throughout the state of Florida, I heard more than once attorneys and injured workers argue that this system just isn't reasonable. But when it comes to constitutional law, if you have a standard such as reasonable, such as rational relationship, such as rational basis, you've got among the lowest constitutional standards, do you not? Anyone aware of a lower constitutional standard than rational basis or reasonable? It's among the lowest constitutional standards. So yeah, we gave you a goose egg. We gave you nothing for pain and suffering. We gave you nothing for loss of consortium. We're denying you punitive damages. You can go see our doctor. We'll pay only up to the fee schedule, and we'll pay you just a percentage of your lost wages. But that alternative is meeting the constitutional standard of reason. So we've got two hypotheticals. How many violations do we have so far of Article 1, Section 21, as interpreted by Kluger versus White? 0. So let's look at hypothetical number 3. The Florida legislature finds that the following causes of action existing since Florida's admission to statehood, by the way, that was before 1968. Causes of action existing since Florida's admission to statehood have now become an instrument of extortion, blackmail in too many instances. So we're going to abolish these causes of action. They may not be recognized in any court of this state. Those causes of action being alienation of affections, criminal conversation, seduction, and breach of promise. Anybody familiar with these causes of action? What are we talking about there? Talking about cheating, people. Cheating. That cheating heart will tell on you. I can't sing. We're talking about broken homes. We're talking about somebody seducing your spouse. What happens to you when that happens? Well, first of all, you lose your spouse, but then you lose some money, do you not? And this is money you wouldn't have lost if that dirty, rotten home breaker hadn't broken up your home, right? That Dolly Parton song, it's famous. So, Jolene. Yeah.
You got it.
Well, I can't sing, but I got those 3 words anyway.
Hey, I mean, you hit notes.
I hit the notes. I hit them right here, didn't I? Yes. So there's economic damages to be suffered by Dolly Parton if Jolene takes her man, right? That's that song. But you know, this could happen to any man, woman, or child. Probably not child. So we're abolishing those causes of action. Does this violate Article 1, Section 21 of Florida's Constitution and its access to courts provision as interpreted by Kluger versus White and its progeny? What do you think?
No,
You say no. Why?
because the public necessity requirement is satisfied by the use of the laws in the way the state is naming them as extortion and blackmail.
That is persuasive. Is that what you were thinking?
Yes.
Was that what you were thinking? There's a hand up over here.
Yeah.
Yeah? Is that what you were thinking? You're correct. That's right. Did we abolish the cause of action? Well, that was in the facts. We said the following cause of action is hereby abolished. Okay? So yeah, we did abolish the cause of action. But did we satisfy either of the 2 exceptions? We don't have to satisfy both. But we did satisfy the other one. This is Rutwine versus Gersten. It's also cited within Kluger versus White. Here, there's both an overpowering public necessity and no alternative method of meeting that public necessity other than Rottwein versus Gersten. What other case law examples exist of facts that satisfy this two-pronged exception? Answer is there are none. There's just that case. Never before, never since have any facts been held to satisfy this particular exception under Kluger versus White. That's why I would argue that it's a hard exception to meet, because I'm just going by the statistics. So far, there's just been one winner, one successful litigant, one case where facts were held to meet that exception. So if you're going to court and this is all you got, time to come up with one of those alternative arguments just in case, because that's a tough one to meet. Hypothetical number 4. In 1973, Miami police, intending to use a tear gas bomb, set off a real bomb instead. Oops. In addition to oops, what else is that? Negligent, right? Okay. So we got an act of negligence. That happened in 1973. In 1974, a bombing victim sues the city of Miami and others. So the plaintiff sues the tortfeasor in 75. I'm sorry, 74. For the tort that happened in 73. Bless you. Now in 75, the Florida legislature enacts a new law. They call it the Uniform Contribution Among Tortfeasors Law. It says in the law that it's retroactive to all suits that are pending but not yet decided. So that would include our bombing victim's suit against the city of Miami and the other tortfeasors, right? Because that suit is pending but not yet decided. In 1976, finally, our bombing victim wins a judgment against the city of Miami and the others. They're jointly and severally liable under this judgment. If I have one judgment against more than one tortfeasor, all of whom are jointly and severally liable, how much does each tortfeasor owe me? The full amount. If I'm the judgment holder, I'm the bombing victim, I'm the plaintiff, and I have a judgment against multiple defendants who are jointly and severally liable, each one of them owes me the whole amount. Imagine, if you will, you're the city of Miami. You're one of the tortfeasors. You're one of the people listed on that one and only judgment where you owe me jointly and severally the whole amount. And imagine you paid a whole amount. What would you like your fellow tortfeasors who are also listed on the judgment to do? You'd like them to pony up, would you not? You'd like them to contribute. Perhaps you might use a law such as the Joint Contribution Among Tortfeasors Act, which didn't exist in 1973 when the tort occurred. In 73, without a Joint Contribution Among Tortfeasors Act, the city of Miami, who pays 100%, can't simply file a motion in the plaintiff's existing case for contribution. Instead, the city of Miami's got to start its own lawsuit suing one of the other defendants listed on the judgment. But now, thanks to the Uniform Contribution Among Tortfeasors Act, Miami can simply file a motion for contribution under the UCAT. Now, say you don't want to pay your share. You don't want to contribute to Miami. You might shout, hey, you violated my rights. I had the right to be sued instead of just facing this motion and this summary procedure. I'm going to lose some money quick. You might yell, there's a violation of Article 1, Section 21 of Florida's Constitution and my access to courts under Kluger versus White, because in the past I had access. I could have a separate suit, and now I just got to hand over the money. Now do I have a violation of access to courts? You're shaking your head. You're saying no. Why?
because the law was created after the statutory period.
Yeah, you see, the harm happened in 73. The suit was filed in 74. It wasn't until 75 that somebody created this cause of action. Can you really retroactively go back and affect my rights? Can you have a retroactive law? Can it apply to all suits pending but not yet decided without running afoul of Article 1, Section 21, Kluger versus White and its progeny? The answer is yes, you can. You can. That was the village of El Porto versus city of Miami Shores. Unfortunately, those facts really did happen. A retroactive provision of a legislative act is not necessarily invalid. Not necessarily invalid. You can pass a retroactive law. Retrospective statutes are only constitutionally defective in those cases where invested rights are adversely affected or destroyed. So there has to be a vested right that is adversely affected or destroyed in order for it to be improper or unconstitutional for a law to be retroactive. Thus, the issue in this case is whether UCAT affected vested rights. Court held that it didn't, because procedural statutes do not fall within the constitutional prohibition against retroactive legislation, and procedural statutes may be held immediately applicable to pending cases. So in Florida, even with the greater protections of Article 1, Section 21 and its access to courts as interpreted by Kluger versus White and its progeny, still we can have retroactive legislation when we're talking about procedural and procedure. Either way, the tortfeasor, who on that same judgment was joint and several liable to the plaintiff, either way, they had a right to get contribution. Before UCAT, they had to file a separate suit. After UCAT, it was a motion filed in the plaintiff's underlying suit. So there wasn't any effect upon the substantive rights. It was the procedural rights. And procedural statutes may be retroactive without running afoul of Article 1, Section 21 as interpreted by Kluger versus White. That is not a violation of Florida's access to courts. Don't believe me? Head down the hall, head to the law library. You'll see row after row after row of old copies of the Florida statutes. They're bound up and they're kept. There's 2018, 2017, 2016, 2015, 2014, 2013, 2012, 2011, 2010, 8, 7, 6, 5, 4, 3. Heads back to the 90s. Heads back to the 80s. Where's the bound up Florida Rules of Court from the 80s? Where's the Florida Rules of Civil Procedure from 1992? Where's the 1999 version of Florida Rules of Civil Procedure? It's not in the library. Why not? Because regardless of when your cause of action arose, today, yesterday, 10 years ago, 20 years ago, if you're still in the courts, you follow today's Florida Rules of Civil Procedure. If they're amended while your suit is pending, you follow the amendment. Go check in the law library. I'm not making this up. So it's not unconstitutional for procedural statutes to be retroactive. And that's why we throw out the old copies of the Rules of Civil Procedure. Nobody needs them. You want one of those? Go to a furniture store. Have you been to a furniture store? They love to decorate with outdated law books. Find it there, but you won't find it in the law library. So we didn't abolish in this case the village of El Porto versus city of Miami in the bombing case. We didn't abolish. We changed the procedure. So far, how many violations of Kluger versus Whites have my hypotheticals illustrated? 0. So let's do another one, shall we? Hypothetical number 5. For more than 50 years, courts and juries have awarded judgments and damages for invasion of privacy based on false light. Yeah, lots of states do that. And for more than 50 years, Florida was doing it too. A plaintiff won such a judgment. pled it, went to trial, won. Somebody took an appeal. The District Court of Appeal affirmed. Somebody managed to get up to the Supreme Court of Florida. You remember how restrictive its jurisdiction was, right? On review by the Florida Supreme Court, nobody raised the issue that invasion of privacy based on fault light wasn't a real cause of action, didn't actually exist under Florida law. But the Florida Supreme Court pointed out, hey, that's not a cause of action here in Florida. We don't have that one. The existence of such cause of action never really existed. And under those grounds, we quashed the judgment, even though no party raised that issue. Have I finally done it? Have I finally illustrated a violation of Florida's access to courts, Article 1, Section 21, as interpreted by Kluger versus White? Have I finally done it? Who says yes, it's a violation? I didn't fool anybody. Not a violation. Why not? The cause of action didn't exist before 1968. It never existed at all. Surprise, y'all. You spent years going to court on that cause of action? That doesn't exist. Reversed, quashed. There you go. It's not a protected cause of action. Has to exist. Hypothetical number 6. Just 2 left, people. Bear with me. Mr. Sibley is duly licensed to practice law in Florida. He represents himself in his divorce from Mrs. Sibley. When he loses the 28th case, I'm not exaggerating. Did you see the Sibley versus Sibley case in the book? Did you see the appendix? Yeah. When he loses the 28th case between them, what once was love is now litigation. Mrs. Sibley alleges that 28th case and most of the other 27 cases were frivolous. So what does she do through her lawyer? Because she's not a lawyer. He's like a bottomless pit of spite, and he's not paying a lawyer, right? He's doing it all himself because he is a lawyer. But her paid lawyer asked the appellate court to stop Mr. Sibley from representing himself in court in the future. Florida's District Court of Appeal grants that motion. We have physically stopped him from accessing the court, have we not?
Yeah.
Have I finally illustrated a violation of Article 1, Section 21's access to court as interpreted by Kluger versus White? What do you think?
No, because
You say no? I still haven't done it.
no, because his reasonable alternative is to be represented by another.
Is to go hire a lawyer.
Afforded the same right.
Yeah. And when he hires a lawyer,
He's not-
maybe that one's ethical and doesn't bring frivolous suits. Yeah. Everyone agree? All right. You are all correct. Because he still has access. He has the reasonable alternative. Go back. He has the reasonable alternative. Your logic is sound. You are correct. And Sibley versus Sibley is a fun read. It's in the book. Yeah. Did you see who else he sued? He sued his wife's attorneys. He sued the judges who presided over the suit. I mean, spite. Yes,
Is there really an alternative if maybe he can't afford it?
that's a good point. And what I would point out to the fact that it's an alternative, but maybe he can't afford it. Or maybe it's an alternative, but they won't bring the same claim. Because as we studied in an earlier class, even a meritorious claim, a lawyer can choose not to bring, even if his client wants to, right? So the lawyer he hires may not be able to afford. If he does afford it, they may not bring it because it's frivolous. If it's not frivolous, they still may not bring it. So is it still meet this exception? And I would argue yes, because it's a reasonable alternative. It's not a perfect alternative. Think of the Florida workers' compensation law. Far from a perfect alternative to tort recovery, but still satisfies reasonable. Because reasonable in a constitutional law analysis is among the lowest standards. So that's why I would say the third DCA got it right in Sibley versus Sibley. This was a reasonable alternative. This wasn't a violation of Article 1, Section 21. Let's look at, that was dramatic the way this floated down there. So I would say that there was a reasonable alternative. And although the case doesn't say, so maybe this was an example of an overpowering public necessity and no alternative method. I mean, the guy's out of control, right? 28 cases against the wife's attorney, the judges in the appellate court that didn't affirm or it was just, man was out of control. So, hypothetical number 7. It's my last one. Do I finally show a violation of access to courts? Let's see. Hypothetical number 7. The Florida legislature enacts a 12-year statute of limitations for harm arising from ingesting faulty prescription medications. And again, these facts are sad but true. 20 years after the prescription drug DES is removed from the market, science learns that women whose mothers took DES, so it wasn't the woman herself that took the DES, the woman herself was still in the womb. Her mother took the DES. So women whose mothers took DES while pregnant, those women, the daughters, not the mothers, those women have a significantly higher chance of cancer. Because while they were in mom's womb, mom unknowingly took a drug that had this side effect. One such woman's suit against the drug manufacturer was brought as soon as possible. But look at the statute. It says you've got 12 years. But it's dismissed because she happened to be more than 12 years old. I finally illustrated a violation of Article 1, Section 21. You agree?
Yes, because it wouldn't have, because it's either the statute of limitation or as soon as the harm has reasonably been discovered. And if you didn't know about it until 20 years after, then there's no way you could have possibly complied with the 12-year statute of limitation.
Absolutely. You're right. It was impossible to bring the cause of action before the law abolished the cause of action. For that reason, there was no cause of action. The cause of action was abolished and there was no reasonable alternative. The case is Diamond versus E.R. Squibb. That's Diamond versus E.R. Squibb, S-Q-U-I-B-B. So if the cause of action existed prior to 68, products liability, negligence, we all agree that existed before 1968? Yes. Then abolishing it violates access to courts. And here, as applied, you remember on its face versus as applied? Remember the difference? On its face, a 12-year statute of limitations does not violate Article 1, Section 21, access to courts. What if instead of a 12-year statute of limitations, I pick just a 5-year statute of limitations? What if Florida says for breach of a written contract, you've got to bring the cause of action in just 5 years? That's a lot less than 12. Is that a violation of Article 1, Section 21, access to courts? No, because you've got 5 years to bring the cause of action. Let's make it a little bit harder. Let's say if it's a negligence claim, it's got to be brought within 4 years, simple negligence. That's a lot less than 5. That's a lot less than 12. Now have I violated? No. And indeed, that is the general negligence statute of limitations within the state of Florida. What if it's negligence against one of us, our dear fellow lawyers? What if you want to bring a malpractice action against the lawyer? What if the statute of limitations is just 2 years? That's a lot less than 4, a lot less than 5, an eternity less, a decade less than 12. Now have I violated Article 1, Section 21, access to courts? No, and indeed that is the statute of limitations for professional malpractice, for lawyer malpractice in the state of Florida. So don't be deceived into thinking that Diamond versus E.R. Squibb stands for the fact that the statute of limitations got to be good and long. That is not the holding of Diamond versus E.R. Squibb. What happened here was the 12-year statute of limitations was not a violation of Article 1, Section 21, its access to courts on its face, but it was a violation as applied to this particular plaintiff and those similarly situated. Because for this particular plaintiff and those similarly situated, they had no cause of action. Their cause of action was abolished before it ever arose. It was in adulthood that these plaintiffs had a higher chance of cancer. It was not in their minority. It was not until these plaintiffs were adults that they suffered the harm. As applied to them, the statute of limitations abolished a cause of action before the cause of action ever existed, and it did not provide anything. There was no reasonable alternative, and it was not because of an overpowering public necessity, and there was an alternative method. It was just denied to them. So finally, in 7 examples, finally, I've got one hypothetical that shows a violation of Article 1, Section 21. We'll take a break before we move on to Chapter 8, but I hope that I illustrated by showing 6 that didn't violate and only one extreme example that violated, but only violated as applied. I hope I illustrated well the fact that although this is a constitutional right within the state of Florida, meeting the requirements of Article 1, Section 21, as interpreted by Kluger versus White, is a difficult task. With that said, let's take a 10-minute break and come on back. Sound good? All right. I'll be stuffing envelopes for 10 minutes. Yes.
Which one did I get you to talk to before class? I got it run. Is that okay?
Oh, hey, you do what you got to do.
Okay.
Okay. Yeah.
That's a case. From the printer? No, from the printer. Do you think this is real? Your case card?
Anyone have the attendance sheet?
I haven't even.
Oh, thank you. Okay.
Are you gonna get your thing?
Almost. I got this far. I will leave to the front of the season. I'm singing a lot today.
Because I was like, first of all, like, what we do about the Congress, and then anything you can do. So that's all you. I was like, we have a question on whether we should.
Less than halfway through.
I was like, and then also like.
Oh, wait, if you're anxious, yeah, go for it. I'll just take him out. Sure.
I was like, if we're talking about silence, I would say that.
More to go. Just have it.
Yeah.
I was like, I guess I never thought about it, like, if I was choosing legislation, what I would do.
And it has
Like, really, I was like, I didn't.
What's up?
Huh?
What's up?
No.
Dead? Not yet.
I thought it was good.
So I got to work this morning. I had a dead body truck. That was the first thing I got to see.
Like how they got
It was too bad of a picture to be able to tell anything. It just looked like something was on the road. Like,
where at?
I can't say.
Where?
I tried to stay like I can't focus. It was good. It was very nice.
Like,
Yeah. Got you.
You know, like, that was so good. But, other than that,
Yeah, I got chili at the house. So dude, I went to Wendy's in a chilly. There's like it's like a chilly day. You know what I mean?
My mom made some, so she sent me home some. They're chili.
My mom's eating one every time I get there. I get like a freezer full. It lasts me like 6 months.
Oh, yeah, I got it in the freezer now, and I'm just like, all right, I got 2 more things left.
Venison chili is the best.
I finally like used all my groceries up. So I'm like, what do I want to eat? I feel like I'm just gonna live it Subway.
My mom's coworker. So I usually go with some sausage around this time of year.
I told Robbie I'd bring some back, or you and him would get together and grill some out. I'd fuck it. So maybe.
If you guys want to meet her, like I'll do something. She'll be down on the 18th, so the day of our final. She's going down. She's here through January 18th, I think.
I'm gonna be in my house the 90% of the time. I'm gonna write my
That's dude, we got 2,000. I have 3,000. 2,000 are usable. If that makes sense. I have to find priority for the other ones because there's for my exam from his old class, and I don't have my notes, and I don't have his handout, and he doesn't have his handouts anymore. It still needs to be cited by an authority. You can't just because this is a military doctrine that I'm writing. I mean, dude, my first or second page rather, I quote Mattis. Like my entire second half is his 2016 assessment.
I
didn't write it. It was for an exam, and I rewrote that. I wrote that essay like a million times and filling it with me. So I still have those. So I just copy and pasted part of my essay. I just need it, but it'll be good. I get to use a lot of interesting quotes. I mean, I cite Trump v. Fly almost right away in my paper.
What are you doing, Mark?
I'm gonna do a little bit of studying. If you want to do some work,
Well, Robbie is talking about doing Miller. I should get wasted either. So
how about this? Grab dinner at Miller's. We study afterwards.
should I be right? Well, yeah.
I gotta show you.
I'm working on a brief.
I got I wrote out the Florida probate code, except for part of the trust section. And my next plan is to compare it to the UPC. Nothing's memorized. This is all written out. It's going to be on the exam in his syllabus. It says UPC. He said most of Florida. Those are mostly the short and dirty for all of Florida.
You got your Y and Slayer statue. Yeah, I see that. Slayer.
Yeah, I was trying to. I was tired.
That was the first thing.
I was tired as fuck when I wrote that too.
Were you going in his syllabus and grabbing all the I mean, that's essentially all I'm
I'm gonna show you I have all the cases too for that class up to chapter 9 anyway. Again, not memorized, but
that year.
yes, you did that last week. But a lot of the cases in here directly contradict the Florida statutes and the UPC. So it's like, how the hell are we going to write our essay? We're going to have an essay in this exam, though. I don't think. He said he wants to get our writing done with his writing assignment at the beginning of the semester, right? Exactly. What? I mean, I'll ask him after class.
I read the syllabus. I think so.
Sure. No. So do you think it would be a good thing right now?
Yeah.
This always happens every single time, except for what they're getting.
Yeah, when you, I was so mad, I was slightly salty that you got the A. You got the A from them? You got A or A minus, where we both got.
I think you got eight.
I was so mad at the minus, I got A minus. Because he ruined my first one.
Alright, Jules.
That would have been so cool,
Well, I'll show you mine, you show me yours.
because obviously I've peaked in so many ways.
Yeah.
We don't really say that.
I think I messed up on something. Yeah. Yeah, what was I
Oh!
Past one, and if your name looks misspelled, it's just because my handwriting is
That's
broken.
amazing.
I apologize.
No, I have. It's been a rough day.
Yeah, take one past one.
Oh, right.
How much is
Be cooler if you-
You know, that was my number on the ERA. No, that was my number on the ERA when I sent down. That's serious.
Oh, you in a big room?
Yeah.
Oh, I was in a little bit.
So I was number 16.
Where'd you? Where'd you go to? Lakeland? Oh, did you go to that terrible old?
Oh, in the hotel, I said, I just took a recent picture.
Why did you stay in the hotel?
Because it's a 2-hour drive if you're in White.
It was not a 2-hour
It was
drive.
hard, dude. I woke up.
I don't think you took it in Lakeland.
Well, you know, it's a good thing I did because there was a traffic accident that morning, so people were late.
Boy, I
It only
was
took,
okay.
I was in
gonna say.
Sanford and it only took me like an hour and a half.
Welcome back, everybody. Welcome back. The envelopes are going around. There's 2 missing envelopes. Mr. Garcia, you're one of them, I think. And there's one other. So I'm gonna fix. You're the other missing. All right, I'm sorry. I'm gonna get it fixed right away. But yeah, sorry for the delay. Yeah. Okay. So take a while to get the grades to you, and now at least 2 of you have to wait even longer. And I please accept my apology on that. So I apologize. So welcome back, everybody. Welcome back, and welcome to Chapter 8, which is the constitutional right to privacy. Now, you're no stranger to the constitutional right to privacy if you've taken a federal constitutional law class, which I hope you have because that was a prerequisite to this one. So, yes, question.
So, as is the actual essay that we did you like make notations of it?
No, I just put the grade. It's in the box. It's a grade out of 25 points. Yeah, so the left side is the grade and the right side is 25. Yeah. Oh, I didn't do that. I just put the grade in. Yeah. Yes, question.
Yes. On the syllabus, this essays were 10 points towards our overall grade.
Percent.
10%. Okay.
Percent. Yeah.
That's what I thought.
So yeah, this probably won't make you or break you, huh? Yeah. Okay. All right. So our discussion then on Chapter 8, our discussion turns now to privacy. And if you've taken a federal constitutional law class, certainly you've encountered a federal constitutional right to privacy. If you've never gone to law school and you've ever watched a news story, you've probably encountered a constitutional right to privacy. So where is this federal constitutional right to privacy? You know, if I pull up the text of the U.S. Constitution, which I'm not sure every judge does, but if we were to pull up the text of the federal constitution, maybe in a word searchable context, maybe it's there on screen in your browser or in your word processor, and you hit a search like Control F and you typed in the word privacy or private or in private or matter of privacy. You keep getting 0 results, don't you? Where is that word in the federal constitution? Where is its synonym? Well, yeah, it's not there. There is no textual basis. There is no text of the federal Constitution that talks about privacy. Maybe you would start your discussion of a federal constitutional right to privacy. Maybe you would have it in Meyer versus Nebraska. There they found a constitutional right to privacy. It was part of the 14th Amendment. Of course, that wasn't one of the original 10 amendments to our federal Constitution. But there in Myers versus Nebraska in 1923, they talked about the substantive due process protection of the civil liberty. Is what they talked about there. They were talking about educating children. They had arrested an individual for teaching the German language. And apparently it was unconstitutional to arrest someone, a school teacher whose job is to teach the German language. Apparently that was a violation of the 14th Amendment, substantive due process, civil liberty. Or maybe it was more fully fleshed out in Olmsted versus U.S. We got to turn in that 1928 case to Justice Brandeis's dissent. So we're not talking about the outcome of the majority opinion. But there, Justice Brandeis's dissent argued that the Bill of Rights should protect the privacy of the individual. So we see the word privacy, at least in the dissent of that opinion. And where was this privacy? Since we can't control F, I guess back in 1928, they didn't have a browser or a word processor. So, maybe they didn't notice that it wasn't in the text. According to Justice Brandeis's dissent, it was implied or could be found from the Fourth and the Fifth Amendment and how they intersected. That was a case where the majority holds that a warrantless wiretap was okay, but Justice Brandeis's dissent argues that that was a violation of a right to privacy. Or maybe we need to turn to Katz versus U.S. That finally overrules Olmsted versus U.S. And of course, in your lifetime, your government has never had, without a warrant, intercepted any of your communications, right? Not in America, not in your lifetime. No. Or maybe it's Griswold versus Connecticut. That was that case. That was a setup. They went there on purpose. They went to that particular place because of that particular law, and they sold birth control for just long enough to get arrested. And back then, I guess birth control didn't directly cause a death, but nowadays, birth control can do that, right? Like a morning after pill or something like that. And you look at God's one holy Catholic and Apostolic Church, you look at its wisdom throughout the ages and always having taught that birth control is a sin. But putting that aside for a moment, the Bill of Rights has penumbras formed by emanations, says the U.S. Supreme Court of Griswold versus Connecticut. And these penumbras, these formed by emanations, this living Constitution, I've laughed about it before, it's running around like a little puppy, right? It's alive. The Constitution, everyone see it run? Is that the Constitution? Sit. Good Constitution. Someone throw Constitution a bone, would you? Because Constitution was alive, they said. Privacy came from the First Amendment and the Third Amendment and the Fourth Amendment and the Fifth Amendment and the Ninth Amendment. Indeed, all these amendments got together because there's something sticking out of the living Constitution. It's an emanation, right? You can't see that emanation. Invisible things don't usually cast shadows, but this particular emanation that you can't see, it casts a shadow. It has a penumbra, right? But to be able to see that shadow, you've got to have one of those 9 eyes. 9 set of eyes. You've got to have that lifetime appointment to the Supreme Court of the United States only with such a set of eyes that's received that lifetime appointment to the nation's highest court. Can you see the shadow cast by an invisible thing that's sticking out of a document that happens to be alive? So where then is the origin of the federal right to privacy? Is it the 14th Amendment? Is it the 4th? Is it the 5th? Is it the 3rd? Is it the 1st? Is it the 9th? Well, I guess the only correct answer we can get is that's the origin of the federal right to privacy, right? It's the case law, right? It's created by the case law. It's judicial activism, is it not? At least on the federal level. It's those folks who are infallible because they're final. If you disagree with the ruling of the Supreme Court of the United States, to whom do you appeal then? Well, there's no one you can appeal to then, right? So it's an act of case law precedent creating a constitutional right, or creating a federal right to privacy. Is that true in the states also? State constitutions, do they have penumbras formed by emanations? No, but they do have language, do they not? And when it comes to Florida's right to privacy, there is language in Florida's constitution. Specifically, it reads as follows. Every natural person has a right to be let alone and free from governmental intrusion into the person's private life, except as otherwise provided herein. Are there exceptions to Florida's constitutional right to privacy? Well, yeah, it says except as otherwise provided herein. So yet again, we don't have an absolute right, but we do have a textual basis for a Florida constitutional right to privacy. So as we compare and contrast to the federal right to privacy, that's one contrast. There's one difference. This one's there. The people voted. Someone made a proposal, they voted, and it became the law of the state of Florida in its constitution. Not because of judicial activism, but because of democracy, because of the vote of the people. So that's where it is. So here's a question for you. Does this Article 1, Section 23 right to privacy in Florida's Constitution protect Floridians from violations by the government, by their neighbors, or both? Who can tell me the answer? There's a clue. Who can tell me the answer? From the government. Yes. Florida constitutional right to privacy is a right that protects us from action by the government. I'm going to cough again. So excuse me, I'll take like a 20-second break to get a glass of water. Otherwise, I'm going to be coughing all over you, and that's not polite. I'll be right back.
Julie?
No.
Sure, it's mere coincidence that I can't talk about a constitutional right to privacy without choking, right? Yeah. Okay, so constitutional right to privacy protects Floridians from violations by the government. Where then can we find protection from violations of privacy from our neighbors as Floridians? Where can we find that? Yes.
When they are acting on behalf of or using government power.
That's true. That's true. When the action of the individual is taken on behalf of the government, that's true. And then the government would be responsible. Because after all, government is of the people, by the people, for the people, and it's run by the people. So there's a human who's standing in the shoes of the government. So you're absolutely right about that. Another thing I would point out, laws that protect Floridians from violation of privacy. Think about things such as slander and defamation. Slander and libel are not specifically separate causes of action under Florida law. Jews for Jesus versus Rapp is the case. Jews for Jesus versus Rapp says that you do have those causes of action, but we call them one and the same. We call them defamation. False light invasion of privacy is not recognized here in the state of Florida. That is not a separate tort recognized by state law. But we do have slander and libel insofar as we have defamation. What are the 5 required elements of a claim of defamation? The first is publication. That may be oral, that may be written. That's how we get both slander and libel. Still exist, even though we don't call them separate things. We call them both defamation. So first there's got to be a publication. Then it's got to be false. You must prove falsity of the matter. Third, skip. Fourth, actual damages. Fifth, the statement must be defamatory. Going back to what I skipped, third, the actor, the one who defames, must act with knowledge or reckless disregard as to the falsity on a matter concerning a public official, or at least negligently on a matter concerning a private person. See the difference there? When it comes to a public official, got to have actual knowledge or reckless disregard to the truth. When it's a private person, there's a lower standard, just negligence. Why hold a higher standard? For example, if the president's mad about the things you tweeted about her or him, why can't the president of the United States just satisfy the negligence standard? Yes.
Because a person in the public light, it's reasonable to expect them to be open to public comment of some kind.
Yeah. We're worried about the First Amendment. We're worried about freedom of speech. Democracy can be a marketplace of ideas. Sometimes we're sensitive. Sometimes we're overly sensitive. Sometimes we can be a little thin-skinned, I guess is the slang term. Sometimes sticks and stones may break my bones, but words will never harm me is the opposite of how we feel. Sometimes we don't want to hear bad things about ourselves. But what about our politicians? What about our candidates for public office? What about our elected officials? Should the rule be, well, we shouldn't say anything bad about a candidate for office or an elected official? No. We want to vet those who want to be our elected officials. We want to vet our candidates. We want to know whether to reelect those who currently have office. We want to hear the bad with the good. We want to put the bad to the test. We want the marketplace of ideas to be out there. We want people to be able to debate. It's the American way to criticize your government. Who among us has not criticized at some point in our lives some elected official? And we probably should. At some point in your life, some elected official will probably do something wrong. And whenever observed an elected official do something wrong, shouldn't we have the right to talk about that? That's where we're going with this. That's why we have. It's the First Amendment. It's the marketplace of ideas. That's where we're going with this. So back to Article 1, Section 23 and Florida's textual constitutional right to privacy. What must I prove in order to win? So I've got the right plaintiff, right? I've got someone who's been harmed. And I've got the right defendant, right? I've got the government or an individual acting on the government's behalf and therefore holding the government liable. What do I got to prove in order to win that suit? The elements of the action are as follows, and they're no surprise to you. First, we've got to have state action. Like we talked about, government of, for, and by the people has to act through a person. But that person had to be taking a government action. They had to be acting on behalf of the government. So that's the first element. Second, there has to be a legitimate expectation of privacy that this particular plaintiff has. Not everything is protected by privacy. Third, there has to be infringement by the state, that's number one, upon the legitimate expectation of privacy. Number two. And fourth, we shift the burden to the state, and the state can't meet its burden to show that the infringement protects a compelling state interest in the least intrusive manner possible. Compelling state interest test, strict scrutiny. None of that's new to you. That was the standard for a federal privacy breach. That's the standard for the textual right to privacy that we find in Article 1 of Florida's Constitution. Perhaps you, like me, enjoy the case of Whitfield versus Florida Division of Parimutuel Wagering because you love gaming and you love to read about gaming. And what happened in that case? A state agency had a job to do. It was auditing the dog track where parimutuel wagering was taking place. Wait a minute, says Mr. Winfield. Maybe, says Mr. Winfield, maybe I did a little bit of wagering over there. I don't want you to know about that, says Mr. Winfield. What about my right to privacy? Under the federal Constitution, in the text, where's the right to privacy? It's not there. Under the federal Constitution, under the rulings of the Supreme Court of the United States that creates the federal right to privacy, Which one of those cases talks about a right to financial privacy? It's not there. We don't have one. Now, I'm not saying that there aren't banking laws. I'm not saying that there aren't codes of federal regulation. I'm not saying that banks are allowed to publicize your bank balance to others. Obviously, that would be a violation of banking laws and code of federal regulations. But what I'm pointing out is that there isn't a constitutional right to financial privacy under the federal Constitution. That's why I like Winfield versus Florida Division of Parimutuel Wagering. Ultimately, Winfield lost. The case held that this agency had a job to do, and in so doing, it could review the bets placed at the parimutuel, which, as a side effect or as a tangent, might reveal what bet Winfield may have placed on a particular day. That was okay and wasn't a violation of Winfield's right to privacy, said the Florida Supreme Court. But in so saying, Winfield holds that a Floridian has a constitutional right to financial privacy. So far, there's never been a Supreme Court of the United States case holding that there is a federal right to financial privacy. So I like Winfield because it serves as an example, despite the fact that Winfield happened to lose the case, that Florida and the Florida Constitution has a right to financial privacy for Floridians that so far does not exist under the federal Constitution. To sum all that up, since the people of the state exercised their prerogative and enacted an amendment to the Florida Constitution which expressly and succinctly provides for a strong right of privacy not found in the U.S. Constitution, it can only be concluded that the right is much broader in scope than that of the federal Constitution. A quote from the Winfield case. Again, Winfield lost, but in so losing, what did the dicta say? That Florida's constitutional right to privacy is broader in scope than that of the federal Constitution. So returning us to the beginning of this class, chapter 1, lecture 1, returning us to that idea of a laboratory of democracy, of states never denying the full range of federal rights, but can experiment and be laboratories of democracy, granting greater or broader rights. Winfield says that Article 1's textual constitutional right to privacy in the Florida Constitution is such an example. It is broader in scope than that of the federal Constitution. We find that the law in the state of Florida recognizes an individual's legitimate expectation of privacy in financial institution records. What if Congress changes the banking laws? What if the Code of Federal Regulations are amended or repealed? Then Floridians still have a right to financial privacy because our state constitution provides it, even though the federal Constitution does not. Is this the same as the federal right? What do you think? Why not?
I think it's more.
It's more. Because it says here that it's more. Yeah. That's the hypothesis of my argument. Now, Winfield lost, okay? He didn't get to protect his financial institution records. So some argue, and I've got the quote in the book there from the University of Florida Law Review, that Florida's right to privacy is no greater than that under the federal. My hypothesis is that it is greater. Why? Because the high court said it is. That's the basis of my hypothesis. Again, I'm here to educate, not to indoctrinate. You can disagree with my hypothesis. That's okay. I put out the hypothesis. You either agree or disagree. I give you the basis so that you can learn to make your own arguments and your own hypotheses. Is this the same as the federal right? I agree with you. I say it's not the same. I say it's broader. University of Florida Law Review disagrees with both of us. Question number 2, is this a misinterpretation of the federal right? Why ask that question? You remember chapter 1, you remember lectures 1 and 2, you remember the essay you wrote. If it lacks an adequate and independent state law basis, then SCOTUS gets the final say. You remember that? If it is a misinterpretation of the federal right, then who gets the final say? Supreme Court of the State of Florida or Supreme Court of the United States? Right. So if it is a misinterpretation of the federal right, then not only did Winfield lose, but the dicta in Winfield's decision is quite fleeting because it denies the full panoply of federal rights, and it's not the final say on federal rights. But if it instead has an adequate and independent state law basis, if instead the text of Florida's Constitution mentions privacy, which it does, hit Control F, type the word privacy, it comes up. And if Winfield says what it says, then my hypothesis is it's not a misinterpretation of the federal right, it's a separate, independent, and greater right. Takeaways from Winfield. What's the standard of review? We already covered it, and you saw it again in Winfield. Fundamental right shifts the burden to the state to justify compelling state interest by the least intrusive means. Difference between federal and state financial privacy. Federal financial privacy, if it does exist, is buried somewhere in banking laws and the Code of Federal Regulations. Financial privacy for Floridian is in the plain text of Florida's highest expression of its laws. It's in its Constitution. Limits upon the Florida financial right to, limits upon Florida right to privacy. City of North Miami versus Kurtz. North Miami was self-insured for health insurance. So they had a great idea. Let's hire people who don't get sick. That'll cut your health insurance bill, right? Right? Who doesn't get sick? North Miami. Doesn't everybody get sick? Those smokers, says North Miami. They get sick. We're not hiring anyone who's a smoker. So Kurtz wants to work for North Miami. She's filling out the job application. Are you a smoker? The application asks. She knows whether she's a smoker or not. So she doesn't answer the question. And instead, she alleges a violation of the right to privacy. Oh, hey, how about that? What do you think? Have we violated her right to privacy? She's working for the city, right? Got a government actor. Answer was no. Why not? Some of you might not know this because you've lived in a smoke-free world for so long. I'm 48. I once lived in a place where people smoked. You'd walk into a restaurant. After the host or hostess said, hi, how many in your party? What was the next question they asked? Smoking or non-smoking? Yeah. And it was brilliant. You had tables side by side, but this one over here was non-smoking and this over here was smoking. There was like 2 feet between them. Yeah.
Yeah, the smoke knew where the line was.
Well, sure, yeah, you'll only put the smokers on that side of the
The
room.
smoke stays in the line.
Oh, the smoke knows.
Yeah,
So the
smoke
smoke knows which side of the room to stay in. I didn't realize that. How about that?
My dad was
You're renting a car. Smoking or non-smoking. You're booking a hotel room and you're checking in. Smoking or non-smoking. Yeah. You're going out after midnight dancing in the club. Smoking. Not that I would know. I just been told. There wasn't a legitimate right to privacy in that question at that time of City of North Miami versus Kurtz. What does this case teach us? It teaches us how to determine whether an expectation of privacy is enforceable or whether it's a legitimate expectation. And how do you know? How do you know whether there's a legitimate expectation of privacy? You look for objective manifestations. Objective manifestations. That's what the case law says. That's the holding of City of North Miami. when and why a Florida court's privacy analysis turns to federal law, why turn to Florida and not to federal? We are out of time for today. Let's pick up next week, right where we've left off with City of Miami versus Kurtz. And let me leave you with this question, and please be ready to answer it. When a Florida court, such as we see in City of North Miami versus Kurtz, has to decide whether there's a right to privacy, does it begin with the federal right to privacy? See if it answers the question, and if not, turn to state and its right to privacy? Or does a Florida court start with the state right to privacy, see if that answers the question, and if not, turn to the federal right to privacy? Is it primacy? Is it supplemental? What is the procedure followed in Florida? That's my question for you next week. Until then, may God bless each and every one of you. We've got just 2 more lectures to go, which means you're almost done with me. We're getting there, folks. We're getting there. Yeah.
Are we gonna have an essay on our final?
No. You've had enough of those, haven't you?
Oh, sorry.